কেবল করেছিস?
হ্যালো। হ্যালো। তাড়াতাড়ি বলুন, তাড়াতাড়ি, এক্ষুনি কোর্ট বসবে, তাড়াতাড়ি বলুন। হ্যাঁ, 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 সব চলছে, সব চলছে। বৃষ্টি হচ্ছে, সব চলছে, হ্যাঁ, সব ঠিক আছে। কি করছে ভাই? হ্যাঁ, পাওয়া যাবে, মোটামুটি normal।
But to mention, my lord, this is the, my lord, pension case. My lord, 12 years, my lord, widow of the deceased person has not getting pension. Due to, my lord, the prolonged litigation was, my lord, pending before this court. However, my lord, 2023 it has been settled. My lord, matter was my lord, appeared before the Honorable Justice Sogato Bhatta due to, my lord, want of determination. It is now, my lord, mentioning, my lord.
Okay, pension matter.
Pension.
Yes.
Okay.
All the list.
Number one for judgment.
I am for the institution.
I am for the petition.
Therefore, based on the discussion and reasons set forth in the
and the lordship. The instruction by the client, let it be kept with the record for our
Keep
safety.
it on the next step. It
It's a
should be,
withdrawal, lordship. My read petitioner, we are
in the circumstances
settled.
today, an order is to be passed.
Already it is settled with the authorities, lordship. So we
Matter
have
settled.
removed our mobile tower. Now, lordship, we want to withdraw the case. It is nowhere related to any private respondent, lordship. We are the mobile tower company, lordship, installed in Darjeeling, Gorkhaland, lordship. Now it has been settled. We have paid. We have removed our lordship. Lordship knows that if it is pending, the company has to show in their balance sheet that the legal pending, this much of pending cases are. So they want to withdraw it, lordship.
Okay. As is a written instruction, sent to the learned, sent to Mr. Upadhyay, learned advocate, repenting the respondents.
No, lordship, we are for the petitioner.
You are for the?
The read petitioner.
So come on this side. Oh. Achha. So you don't want to proceed with
Yes,
the.
lordship,
আচ্ছা আচ্ছা
Full.
আপনি করুন যে মিস্টার উপাধ্যায় লার্নেড অ্যাডভোকেট রিপ্রেজেন্টিং the petitioner submit that petitioner grievances have been redressed and the mobile tower
Three and four.
withdrawn.
3 and 4. 3% incremental benefit, but the other side is coming over phone. I have been informed. Made it short pass over, my lord. He has come in the bar.
Same matter. Same matter.
Both are same. 3 and 4. Same matter. My lord's order is there. Only correct.
Okay, passed over.
Pass over. My lord, he is coming. Over
ওই এই অর্ডার তো সুমন বাবু
হ্যাঁ,
পাস
আপনাকে
করবে
দেয়া-
হ্যাঁ আপনি পাস করবেন তো আমার পাস করার দরকার নেই আচ্ছা ইয়েস
Number 5.
We are appearing for the respondents. my lord.
Being short password, but he's coming.
whether it would be
My lord,
taken up today.
my lord, it is coming for the first time on the list. Kindly gives us a date. We will file an opposition. Then my lord can hear it out.
Opposition. So I am to apply this mind whether opposition is needed or whether at the motion stage it can be disposed of or not.
Yes, yes.
My lord,
Uh,
that is my lord's.
so come tomorrow.
Password, make it password.
No issue.
Are you ready?
My lord, this has come up after a long time, my lord.
Are you ready with the matter?
Partially ready, my lord, but
Partly ready.
not completely. I need some instructions from my client. That is all. It has come up after a long time. So
So not this week. Come in the next week.
Year 2021.
Yes, sir. Next week it would be disposed of.
Not password, not only kindly.
Don't worry here in this court, it would be disposed of next week. But don't kill your friend who went unprepared. Ask, bring him his weapon.
In all matter, I am not against.
You will kill a
I am but
warrior without any weapon.
at this last stage, but we are octogenarian, nearly octogenarian. I never.
Okay, passed over. Let's see. Okay, passed over.
Yes, yes.
Ask your learned friend who will move the petition. Okay.
Okay.
Yes, yes. Yes.
Number 6. I appear on petitioner.
No respondent. So not today, what can be done? You have adopted regulation. Not today.
Number 7.
I for the private respondent, my lord. I am for the added respondent, the commission.
Added exponent. Petitioner is not there. Taking advantage of this day. Okay, not today.
Eight.
Yes.
Number eight.
Eight. You are eight. You are for eight. Oh. Oh. Where is their decision? You have to not to release.
Yes, my lord, on the last occasion,
Huh.
I have served him and I have selected
Served
private respondent number 5. My lord required
Mr. Bhattacharya is private respondent. Is
in dealing with the matter on the last
Oh.
occasion, my lord considered it that the presence of private respondent is necessary. That's why there was a direction on me to serve a copy.
How the private respondent is related to this account?
Actually, what happened, my lord? He happens to be daughter-in-law. The account lying in the name of the husband and the private respondent. But this thing has been settled by way of grant of probate on also settled between the parties by way of compromise. All these things, my lord, is part of record. Now the postal department is saying that since the original account is lying in both the names, B type of it, they cannot be given. Facts remain, my lord, matter has been settled between the parties. Everything has been
The account opened by whom?
account opened by the husband with the wife.
Husband or
Respondent
of
number 5.
private respondent number 5. Okay. Husband died.
Husband died in court.
Either or survivor. Mode of either or survivor.
Husband died, but
The husband died, so what prevented the wife to operate? Either or survivor is the mode of.
this is not the case. What happened, my lord? The petitioner before your lordship and the husband of respondent number 5, they were brothers. 3 brothers.
Petitioner, who are the petitioner?
Petitioner is, my lord, Somendranath Rai and Sukumar Rai.
Sukumar Rai. They are sons of late Bholanath Rai.
Yes. And Rimpa Rai, respondent number 5, who happens to be the wife of Purnendu Rai. The petitioner and Purnendu Rai are 3 brothers.
Oh.
And Rimpa Rai is wife of one of the brother.
Hmm.
In course of his life, this Purnendu Rai bequeathed a will. There were certain conditions out of the same that he will get all these things. That will has been probated. Ultimately, my lord, between the parties, Rimpa Rai and Somendra Rai and Sukumar Rai, it has been settled by taking one-time payment of 15 lakhs. He is really all this. He is liable to the postal department will release it. All these things has happened. I have showed till I am last showing. Now, other accounts postal department has released. Only 1-2 accounts, not huge amount. This thing postal department is not releasing. According to them, it is a B type. They cannot release it. This is the case.
It is joint account.
Joint account.
So how they will release?
It can be released.
And is this compromise whether binding upon them?
Yes. That's the term.
They are not a party. Postal department was
Yes,
not the
postal
party to
department
to the compromise settlement.
Yes, they were party. Postal department was
How?
party. Others have been released. I lordship kindly sees the
The
document.
compromise you entered into with the private respondent, postal department was not party to
Yes,
that instrument. So that instrument,
Yes, lordship kindly turn to.
so that instrument,
Yes,
that postal department was one of the signatories.
yes. Now, compromise is not required, but for postal
It
department.
cannot be, Mr. Roy.
That's true, that.
Okay, today it would not be proper to take up this matter because you adopted a resolution, so make it not today. Huh?
Would your lordship take it on record that I have served him?
File affidavit of service.
Give me service.
Huh? File one affidavit of service. That would be better.
Yes.
If ultimately court is compelled to pass order in absence of petition, respondent number 7, that would be defense for you.
Yes.
Not this week. Not this week. Okay, so not this week. Come in the next week.
Number 9.
You, Mr. Rai, you look into that aspect. Joint account means the money lying in the account belongs to both.
14.
And mode of joint account, most probably, in most of the cases, mode of operation would be either or survivor. Joint account means jointly, the property is joint. You come think in this from this angle. Property is joint. It is neither the property of that person. This property on the death of one of the account holder will go to another. Here, this property cannot be stated to the property of the person who has died.
But facts remain, my lord. If by
Or estate.
my submission would be, if by a judicial proceeding, the party in whose favor it has been relinquished, he has decided to forego it. By judicial verdict, judicial dictum, judicial record, the relinquishment in whose I follow that joint account on the death of the one of the party, it devolved upon the another person.
Yes.
Correct, my lord. But
Yes.
facts remain, if it is on record, that party has relinquished that. So what is the problem of postal department? He has relinquished it. He has said that I will not take it. It will go to this person, and in lump sum I have taken 15 lakhs. I am satisfied with this. If that be the position, what would be proper?
What is the problem? He will withdraw the amount and he will hand it over to the
Now,
to the petitioner.
if Dorship pass this order,
Actually, you are asking the court, every account holder, given instruction or direction to the bank how the account will be operated. Direction is from the very beginning, at the time of opening of the account. The mode has not been changed during the lifetime of both the account holder. Has not been changed. This direction is binding upon the bank. Now it is a personal arrangement in between the petitioner and the private respondent. That cannot be stated to be binding upon the bank, and you will say, and this will not override the instruction given by the account holder at the time of opening the account.
I fully bow down. Supposing, my lord, if property is probated, it goes in my favor, it lies in a bank account, it is not binding on bank? Simplicitous thing. And asset is lying with the bank. Supposing certain money, thou by way of probate, by way of decree, I got it. Supposing I keep it back and soak it, whether it is binding on bank to release it.
In that circumstances, your remedy not lies to force the bank to override the same. You allow the private respondent to withdraw the amount. And if by virtue of the probate, you are entitled to get any share of that amount, your remedy lies to file a suit. Yes, to file a suit, but don't ask a financial institution which is governed by a banking law and which is honoring the instruction given at the time of opening the amount.
What happened? She is watching the matter by other process. Immediately it is when any order is passed, he will take steps.
He has married.
So I can dispose of the private respondent may withdraw the amount. Bank will hand over the amount to the private respondent. And if the petitioner can prove that they have any claim to that amount, they are at liberty to take appropriate steps. You file a suit. That by virtue of this probate, or the amount was bequeathed to me, and since I one of the beneficiary of that probate, I am entitled to get. That would be the proper.
Others account.
You think about it.
Yes.
You come.
Some order may be possible. It was hard at,
Okay.
some order may be possible.
Acha, hard. Next.
Restrict to the, my lord, the other side has come. Pass over.
আচ্ছা, 9টা দেখে নিন, তারপর দেখি। Item number 9.
For the state, my lord.
Okay. So not today.
Number
Not today. Okay. Now, ever call the Passover matter to
Item number 3.
item number 3. Who is your other side?
As per direction of the honorable court,
3%, 3%.
I may permit to file a affidavit in opposition.
আচ্ছা, ঠিক আছে, affidavit opposition filed on behalf of the state respondent is taken up. Use the any reply to that opposition. ঠিক আছে? আচ্ছা, এবার উনি অর্ডারটা দিয়েছেন, আমারই অর্ডার। না না, একজনই হবে। এরা সব ওই 3% যেটা নিয়ে এসেছে। Same, you are appealing for 4? হ্যাঁ, affidavit. So if he is engaged, no, today it would not be, yes, Smita Das Day. Oh, he is no more in the panel.
Elevated as a judge.
Oh.
So he may be engaged same matter, my lord, the court order, and he will engage be recognized by the court.
So not today he will take instruction.
As same matter, my lord, everything, I will supply all these, my lord, petition, everything. Same matter. On the same day, we will execute both the matter.
Mr. Ali Lanet, advocate appealing for the petitioner, has pointed out that the Lanet advocate who
My lord. Affidavit of service. First. Lord, the people substance of this case is very much clear and specific. One Paresh Chandra Bhawal, during his lifetime, executed a will, both movable and immovable property.
Okay, I'm coming to you here.
Yes, my lord.
What you have challenged, the order passed by
Yes,
the
my lord.
Ombudsman.
Yes, my lord. Punjab National Bank wrongly deposited a sum of rupees 20 lakhs in favor of one of the co-sharer, Chanchal Bhawal. That is only the questions. And that questions as I urged before this learned ombudsman officer, but ombudsman officer negated this very particular application, directing that there is no deficiency of service. Against these very particular deficiency in service, I made application to the Deputy Governor, Reserve Bank of India, Appellate Authority. Who is the Appellate Authority? 19th floor, Central Officer, Mumbai. But, my lord, against this very particular action on the part of the Ombudsman officer, it is very much clear and specific that the Chanchal Bhawal has no right to transfer the term deposit, a sum of rupees 20 lakhs.
Oh, why are you shouting?
My
Change. I am also suffering from same problem.
same problem.
Yes, loud voice. You are hearing this. So you have to control.
Fine.
Learn to how to control the voice. So you, before inviting the court to enter into that dispute, you come to your rejection order. Actually, you have challenged the rejection order of the Ombudsman.
Yes.
Okay.
Yes.
So Ombudsman
Page 60.
has 60.
69.
69. Okay, it is 9. Ombudsman has rejected on the ground that the complaint is not on the ground of deficiency under clause 8.1 and 8.2 of the BO.
Right.
BSO.
Rightly pointed out.
You show us now BSO clause 8.1 and 8.2. Have you annexed it?
No annexed. But
So you supplement
this is
supplementary period.
He subsequently filed, sent the matter to the Deputy Governor of Reserve Bank of India. That's why it has not been annexed. But if your lordships kindly give me 1 day time, I file supplementary affidavit and filing this.
Yes, file supplementary affidavit. Or you bring it. It is a BOS means.
I have to look it up. I cannot. My lord, I cannot recall it at the current moment. My lord, I have to look it up for a moment.
Oh,
BOS.
you are representing the bank, so you
I am for the private
know this
respondent.
technical term.
No, he is private respondent, my lord.
I am the private respondent,
Oh.
my lord.
Who is
The
appealing? for the
heirs of the
bank?
Chanchal Bhawal, my lord. Heirs of the Chanchal Bhawal. Paresh Chandra Bhawal.
What is this? What you have submitted it?
Submitting Miller's Paresh Chandra Bhawal during his lifetime.
No. Why? If you want to submit anything, submit by way of filing supplementary affidavit. Okay, in this way, the paper cannot be placed. So today it cannot be taken up. I adjourn the matter for this week. In the meantime, you file supplementary affidavit. You bring BOS. First, satisfy the court whether the grounds taken by the Ombudsman to reject your complaint is correct or not. They are saying that it is not, most probably not deficiency of service on the part of the bank. It is the conclusion of the Ombudsman. You are aggrieved by this decision. So you are to challenge that this decision is not correct. You have to prove that first before inviting court to enter into the question who will get the amount. Okay. So come with here.
And my lord,
Not this week.
my lord, the question put to me, my lord, BOS stands for Banking Ombudsman Schemes. That
Have
under
you bought it?
no, my lord, that I have a digital copy, my lord.
Digital copy.
But my lord, since I'm appearing.
Bring his hard copy on that date. Okay. Bring his hard copy of that date so we can conjointly read.
And my lord, kindly records that the bank nobody is representing the bank.
You are not bank,
I am the private respondents.
private.
Give a notice. Today I am not passing any order. Okay.
And then.
Okay, not this week.
Not this week. I'm
Yeah. Please call the application. Item number 10. Yes.
Writ petition applicant, my lord. Ashok Jain appearing for the respondent, my lord. He is in agent code number 13. Can you short pass?
My lord, this is substitution application, my lord. Service is complete, my lord. The writ petition has died on.
But whether you have not instruction to appear, only instruction to pay for adjournment.
No, my lord.
They are paying for substitution only.
Substitution, my lord. The applicant are the wife and the son's legal heirs of the writ petitioner, my lord.
This petitioner has died.
My lord. And my lord, this matter has been remanded to the single bench by the the judgment of the division bench, my lord. That is annexed at page number.
Okay, yeah, let them come. Today you have adopted a resolution.
So, pass.
So, not today.
Not today.
Not today.
If you agree, my lord, can it be? If my lord, please.
Substitution, a short order will be passed.
My lord.
Okay, on that date itself, it can be disposed of along with the main matter. Okay.
My lord.
Today or hobe. Okay, not today, come tomorrow.
My application, Lordship. Restoration application. There is a delay of 27 days, Lordship.
What is your instruction? What is your stand?
File may be restored, Your Lordship.
Huh?
This application may allow this restoration application, Your Lordship.
Which is the can application? Which
One
is
is
the
restoration, other is delay.
section 5 is 2 and restoration is 1. Hello, can 2. I mean, ছুটি তো হচ্ছে না। বললো মামলা করবে না কি
Item number 12.
12 by appear.
Where is the other side?
That's the problem.
So not today, they will not come today. Yes,
13.
But for the lead petitioner. My lord, pursuant to the direction passed by my lord Justice Mr.
Subhendu Bandyopadhyay, this matter is for LIC, my lord. My lord, during the disruption of the weather and the, my lord, train, he is not coming today, my lord. Will it be taken up tomorrow?
so
My
not
lord, this,
today.
my lord, this is the affidavit of service.
Okay, keep it with you. Tomorrow, today you have adopted a resolution. Okay, come tomorrow.
Number 14.
14 for the petitioner. For the respondent number 11. Former respondent.
So all are not present. Now what can be done, Mr. Panda?
So, my lord, the allegation against the school authority.
Adverse order, you have adopted a resolution that in absence of,
School authority is applicable. My lord, give
meet tomorrow,
next tomorrow, day after tomorrow, my lord. I have some.
over day after tomorrow.
Only, my lord, only give you mark to my lord.
হ্যাঁ
Mark in the list, so my lord, it can be.
হ্যাঁ এই আপনার আজকে কত তারিখ জানো 9 তারিখ না এটা 11তে মার্ক করে রেখে দিন তো ইয়েস ও এই 14 তারিখে করা যাবে প্রচুর So I'm keeping it on 15th. 11th, I have a division bench in second half.
15.
15th,
Or my lord, tomorrow after 2 p.m.
2 p.m. Audio side matter tomorrow. So not today, not today.
If my lord today, tomorrow, if I am not appear, my lord, I shall my lord pay.
Yes. Not today. 15 also. 15 year matter. 15 call.
Yeah.
Will not come. You have adopted. Oh, all are not present.
No. Subject to correction, you see, mother. The state, my lord, the 15 of the salary. Yes, well, the rejection by the state. How my landed finance says the school authority. Maybe my lord kindly. Maybe my lord kindly see the region order.
This is my lord, one thing, this is a motion stage, not my lord hearing.
May not be my lord kindly see the lordship determination.
Okay, but today all party are not present.
Very.
You yourself have adopted a resolution. We have received the same. In absence of such and such, no adverse order should
That
be.
different thing. My landed finance, my lord, allegation is absolutely.
Okay, not today. Come tomorrow.
15. Item number 15.
Not today, কি করা যাবে আর?
For 17, for the petitioner, this is a contempt application. The first time, my lord, I think, my lord, the state or my lord, the
No, not
and
required.
if your lordship's order, my lord, despite lordship order, till date, they have not taken any decision. Lordship has specifically observed that there is no bar for pending of the criminal proceeding to resume his duty. Following the Honorable Supreme Court judgment and my lord, the High Court judgments also. My lord.
Oh,
My lord, kindly see your lordship's order. Page, my lord, elaborate judgment and issue page start from 17. My lord, 14th May 2025, lordship has passed an order directed to my lord within 6.
আরে আপনি লিখুন তো সুমন বাবু লিখুন আচ্ছা মিস্টার পান্ডা
Lordship, learned counsel Mr. Pratik Majumdar could not come to court today due to he is suffering from high fever, Lordship. I am only praying for a not today, Lordship.
Tomorrow he will come.
Lordship, he is not well, Lordship.
Oh, that matter.
Yes, Lordship.
Eh?
Yes, Lordship.
You have challenged virus of certain provision.
Yes, Lordship, my senior would be in a position.
Only not today we will.
Not today, Lordship.
Okay. Come tomorrow.
Item number 19.
19, my lord, I appear for the petitioner, lordship. I am prepared, my lord.
What can be done?
My lord,
Today you adopted
Lord,
education.
may I serve a notice upon the learned advocate appearing for the respondent and come back next week, Wednesday, pursuant to subject to my lord's convenience?
Next Wednesday.
Next, because lordship, 5 crore I have deposited with the respondent authorities. I'm not being able to recover that money. It's a not a disputed fact of law. It's an admitted amount. 5 crore, lordship, pending since 2016. It is about frustration of a contract, lordship.
রিটার্নেবল হিয়ারিংটা আবার কবে দেবেন? তাহলে নেক্সট বুধবারই দিয়ে দেবেন রিটার্নেবল হিয়ারিংটা, হ্যাঁ, 16 তারিখ। So it will appear on 16/7.
Lordship, may
It
I
will be
serve
placed.
the-
It will be placed in such a position. It will be taken up for it.
Deeply obliged. May I serve a notice in the meanwhile, lordship, if lordship so directs upon?
No, in that circumstance, I am to pass an order. It would be actually here we reshuffle. Today, a returnable matter will be placed at the top so that it court can reach.
Yes, my lord.
Tomorrow, upgraded matter will be placed at the one day. Pathar matter will be placed.
My lord, subject
So
to
on
lordship's
16 July, এই আপনি ভালো করে শুনেন, 16 July, returnable matter, hearing matter will be placed at such a position, it would be taken.
I'm deeply obliged,
Okay.
my lord, deeply obliged.
Okay.
Number 20.
But petitioner is not here. Oh. So 20 not today. Today, even if they come, they will not come in the court. Eh? They will remain in bar, but today they will not come. Eh?
Any day.
Okay.
Similar 20, private respondent is presence is required, my lord. I am also
Oh.
petitioner, my lord. And not today, make it not.
No, not today.
Private respondent.
You,
No, I am a petitioner, my lord.
or private respondent.
Private respondent.
Oh, PWD land.
My own land, my lord. Panchayat.
They have already started construction.
No, my lord. My land, he also made a construction
Panchayat.
in the Indira Awas Yojana. Last occasion, lordship, direct the serve the notice. I also serve the notice, my lord. Notice is yes, my lord. Not today, one of his person.
Okay. Oh.
22 with 23 and 24.
আসবে না, গল্প জমিয়ে দিয়েছে বারে, দেখুন। নট টুডে আর কি,
এরকম
25.
this matter can be disposed of with the
25.
all parties are there.
even then subject to correction.
I'm on behalf of the state, lordship.
yes.
I'm being,
State, only state is the authority.
lordship, I'm being led by Advocate Abhishek Prasad, lordship.
শুনুন আমি কি বলি, this matter can be disposed of. The impugned order which has been passed, but I have read this to some extent correct. Well, it is a approval minority institution. Petitioner was the teacher of that particular school. Now she had the qualification but percentage of marks below that as per eligibility criteria.
As per eligibility criteria, yes.
Now the panel was prepared. Minority institution, no question of prior permission is required. Your lordship already held in some of the matters. Now, panel has been sent to the district inspector for approval. District inspector, upon scrutiny of all these documents, held that the selection process in which the petitioner participated, the MS or MS master degree does not qualify the essential marks, that is 50%. Now, I got the 50% mark in a subsequent MSc degree. So, on the date of interview, I did not qualify that. That selection process must be cancelled with a same fresh selection process to be conducted where the petitioner may be directed.
You selected.
Yes, I was selected.
I was selected, but district inspector school refused to approve your appointment.
Approval of appointment.
Approval of the appointment.
Because of the fact percentage.
Challenging the same, you came.
This is petition.
But admittedly, on the date of interview, you did not meet the eligibility criteria.
Percentage of marks.
Subsequently,
I got.
But
reflection in the order sheet itself.
But the why second impellent candidate will not get?
No question. No.
Post of
headmaster.
Lordship,
Post of headmaster.
Oh.
I participated.
There is a one-man panel.
One-man panel. Correct.
Lordship, there was a direction to file an opposition, Lordship. We have filed.
Accept there.
Lordship, may kindly
Inter panel should go.
And fresh selection process.
Yes.
You are appearing for the state.
I am being led by Advocate Abhishek Prasad, Lordship.
You are not in the panel.
No, Lordship.
Because single man panel was prepared, it was sent. One can see the impugned order itself. It can be disposed of.
So you cannot take responsibility of.
I am not paying for approval. I am paying.
Yes.
I am paying for this order should sustain and that fresh selection process to be conducted.
But direction is to be given to initiate
upon the school.
On the school.
Lordship may then make it not today, Lordship. I am keeping.
Not
Let
today.
it be 2 minutes and tomorrow then. It can be disposed of by 2 minutes.
Lordship,
but I have not
let it be on
satisfied
Friday, Lordship.
it is a minority school.
Lordship, may kindly fix it on Friday.
Paid 52. And it is held.
You know who is appearing for the school authority. So, if we placed under the heading to be mentioned, they will say that.
Which have a notice.
Or let it remain in the list.
Yes.
I shall come.
Yes.
So, Lordship, may kindly fix it on Friday, Lordship. I am praying. Lordship. Because due to his mother's illness, he could not come today. He will not be able to.
Okay, but come on next Wednesday.
Already used to take up this matter on Wednesday.
Wednesday the returnable matter গুলো দিয়ে দেবেন তো Wednesday বুঝতে পেরেছেন ওই 16 16 হ্যাঁ 16 yes
Get put to Lordship.
yes
Personally, don't have satisfaction that panel should sustain. Otherwise, I could have argued.
yes
I could have argued.
yes very good submission fair submission okay
Much obliged, Your Lordship. That is why I took time on the other day. Let me
take instruction yes
Number 26.
26 all parties are there so all are present.
My lord, this is goods and service tax matter, my lord. Refund application rejected, my lord. Thereafter, my lord, appellate authorities order passed. Thereafter,
Only thing, my lord, I am today handicapped to the situation. My lord, I see the reply had been filed. I do not know the opposition has been filed or not.
No, not filed. It is with him, not filed.
Well, then I am praying for not today. Just my lord, I will get the opposition and file it because
I received the opposition and submitted reply yesterday. Learned friends having.
So not today.
my lord, can you keep it on Tuesday, my lord, next Tuesday? I'll take
No, it would be on Wednesday.
Wednesday, my lord.
Wednesday. It would be.
I'm grateful, man.
Grateful.
And I tendered apology for yesterday, man. There was an issue with my daughter.
The person from Delhi is coming.
My daughter's
He has concluded.
had stuck in the due to the water logging.
Waterlogged, my lord.
I had to go to her school and take her. So that was the issue.
Oh.
That was the personal issue. Or else I would have, and I'm prepared in the matter. I'll go.
So on the next day, you conclude your argument.
It takes some time. It's a very important issue. Virus of the two provisions are challenged. But it will take some time. When it doesn't go for the virus, then it's
Keep
okay.
lucky, appear.
Because when I do not know whether he has served to me, he gets angry with every sentence. Attorney General, because the virus of a central act is challenged, I do not know he has served to the Attorney General or not. That is the norm, my lord. He has challenged the 73(5) section of the GST Act. Man, I don't know, man. 73(5) challenge করেছে 5 মানে everyone gets surprises that for that challenge. Challenge করেছে এবারে যাই হোক আমি বলছি that is the difficulty. The central government has to come and first argue on this. Attorney General should submit. That is the procedure followed by Chief Justice. And
Okay, you remind this fact to me. Okay, you remind this fact on that date. It would be brought to his notice.
I will
Notice
he
of
gets angry, my lord, very quickly.
No, on that matter, I am not appearing.
no, Mr. Mittal.
Oh, okay.
Mr. Mittal, since he comes from Delhi, I can recollect. He mentioned this matter that I am coming from Delhi. He concluded his argument, but argument from the central government and state government are yet to be completed.
This matter, my lord, same position, my lord, on Wednesday. my lord.
Yes.
I'm grateful.
Yes.
7.
I am for the state.
Compatible appearing with my lord, she could not come, my lord, praying.
The exchange of affidavits, my lord, is completed. This matter.
Okay, not today. Upgraded, not today.
28.
Lordship, for the petitioner, the counsel in this matter is busy in some other court, so if you could give a short pass over.
Not today, not today. Hmm.
29.
Lordship, I am for HMC and led by Mr. Shontiban Banerjee, praying for short passover.
Not today, what can be done?
Then kindly make it, my lord, day after tomorrow, 11th.
Day after tomorrow it would be.
Lordship, kindly fix it Friday.
Friday কত ম্যাটার ইয়ে করে 1 PM facially fixed matter, 2 PM matter,
My lord, this week.
and there is a chance of
May
330
submit-
on
may
your
submit
behalf.
My lord, my lord,
On that date you will close the court early.
this will take, my lord, 2 minutes.
Friday.
Only one thing, my lord, corporation, my lord, certified under the, my lord, in reply to the RTI, my lord, that no sanction building plan has been passed in respect of the construction in question. Only direction will be given to conclude the proceeding, giving an opportunity to all interested parties. That's all. But it will take, my lord, only 5 minutes, my lord, to pass an order. This, my lord, document is enclosed, my lord, that corporation certified that.
Okay, it would be taken up on the date when updated matter will be placed at the top. Okay. Keep watch on the list.
Or, my lord, since my learned friend is, my lord, praying for time, my lord, it can be passed over, my lord, or fixed. What are some asked?
State Bank, item number 28.
29.
29.
Howrah Municipal Corporation and others. That means not all are present. You are for?
Corporation.
Corporation. That means state is state.
Private respondent serve.
So
Last occasion also they did not appear.
so today it cannot be.
Then make it then not today.
Not today, only not.
Let me come tomorrow, my lord.
Yes. They come tomorrow, I am not. Hey, yes, tomorrow they কি থাকবে? Okay, I am seeing what matter can be placed at the top.
আমি বলছি কবে দেবে সেটা বলো।
ওকে, আপনি বিকেলবেলা আসুন, দেখা যাচ্ছে বিকেলবেলা। আপনি বিকেলবেলা আসুন, নাহলে লিস্টটাকে ধরা যাচ্ছে। ইয়েস, আসুন। Yes. It will written in the list, and it is just 3 matters under the heading upgraded matters. Upgraded matters will be placed. Every matter will be upheld. Patal matter, returnable matter, upgraded matter. Keep watch on the list. Any day it would be taken. Yes.
Grateful, Lordship.
Item number 30.
Item number 30, I am for the petitioner, Lordship. This is the matter for hire case held, Lordship, not get by the petitioner, Lordship. And regarding this matter, Lordship, but I have mentioning before this court, Lordship, after getting the notice, but They have not in service, Lordship.
What can be done? Not today. All are taking advantage of your resolution.
Tomorrow, Lord.
Eh?
Tomorrow it taken up, Lordship.
Most of them has come now in the bar. Eh?
Fix the Lordship.
Okay, yes.
Fix the matter, Lordship. At any time, Lordship.
On that date, again the updated matter will be taken up. Your matter must be taken up. Don't worry. Keep watch on the list. Yes.
May I permit to mention upon notice, Lordship?
No mentioning is required. No mentioning is required. It has been placed under that. It will be retained in its position. Okay.
What do you want?
One, my lord, I appear for the respondents, my lord. Probably its matter is mentioned before your lordship, my lord. Thereafter it has come. The learned advocate for the petitioner has come, my lord, but I must be very candid, my lord. Another matter is fixed as against me in court number 2. It will be taken up right now.
Oh.
That's why, my lord, the resolution is also there, as your lordship was observing. Everyone's taking, my lord. This matter be taken up on any day, my lord.
So not today.
Not today. Very good, my lord. Grateful, my lord.
Yes.
32, my lord, I appear for the respondent bank.
Petitioner.
My lord, both parties are present, but my clerk has missed the brief today, your lordship.
But my lord, I tell your lordship, my lord, the urgency is, my lord, this is, my lord, where, my lord, the classification was NPA was done in violation of RBI guidelines. The violations are apparent. I am enjoying an order passed by the division bench that they should not take any surface action against me. Now the problem I am facing that on the strength of the same NPA, they are proceeding in the NCLT. So that is the urgency because the company will go into liquidation if Malad, the matter is not taken up. So Malad, all I am saying, Malad, I can start. I will start, Mr. He also leading me. Malad, we will conclude it. It will not take more than half an hour. And next day she will reply on Monday.
My lord, it will not prejudice them for only one day, my lord. Tomorrow I'll be having
I
my
am not
brief, my
saying,
lord.
I am not inviting your lordship to pass any order. All I am saying that may I place my facts so that tomorrow.
My lord, I'll come ready tomorrow with my brief, my lord. Let them have their argument tomorrow. If it so commences, your lordship. Kalke, na.
Can you do a top of the list, Lord? Very small point is involved.
Let it be there.
And in matter
আচ্ছা ইয়ে আমি একটা অর্ডার করে দিন হার দ্য লার্নেড অ্যাডভোকেট অ্যাপিয়ারিং ফর দ্য রেসপেক্টিভ পার্টি লিস্ট দ্য দেবেন তো কি ম্যাটার দেখা যায় ওকে আর ইয়ে শুনুন লিপটা পাঠিয়ে ইয়েস
Number 33.
Petition. Well, this matter I have mentioned before Lordship and having an innocuous fear that matter is very vital and it's a question of Battle of Waterloo. But I cannot move the matter in details because my client is going to retire on 31st July 2025. He has made an appeal to the review authority and my Lord Justice Mantha also directed that was not given. Only this.
Today are you ready?
Yes,
You are
sir.
for, you are for?
I'm for the I'm for Coal India, Your Lordship.
Coal India and others.
Yes.
Which a Union of India is there.
Union of India is there.
So all party is not there.
I am only making the
Only
innocuous
for Coal
fear.
India, Your Lordship. The matter can
Only
be heard,
Coal
Your
India.
Lordship.
Only Coal India. Kindly see the cost title.
আমি ইয়ে কোন
No union of There is no union.
having আর ইয়ে আপনি
One,
ইয়ে
two, and
করুন
three.
বলে দিন ইয়ে বাহাতে উঠবে না। Okay, let's see. Only court. হ্যাঁ। Yes. What you have challenged?
And I have challenged the Lord because they are having the giving me the dismissal order, because on the same charge sheet, they have imposed me two major punishment. First of all, in the same charge sheet, they have imposed me major penalty, reduction of rank for 1 year in a lower scale. Then thereafter, I have paid for an appeal. Appeal is pending. During the pendency of the appeal, I have already suffered the punishment.
You are?
Suffered the punishment. Thereafter, they issued another show-cause notice on the basis of same charge sheet. They're saying that we are entitled to enhance the punishment for dismissal. They have not started any
appeal decided against you.
Appeal not decided against me. It was pending first time. There are two appeals. Against two major punishment, two appeals. First of all, they preferred major punishment, imposed major punishment. I suffered the punishment during pendency of my said appeal. Thereafter, they have imposed another show-cause notice on the basis of the same charge sheet. They said that we can enhance the punishment for dismissal. Then against of that, I preferred the show-cause reply to against show-cause notice. Then come to the honorable court. My Lord Justice Mantha has directed my Lord to give the opportunity hearing to the prefer a reply to the board of directors, because the dismissal order passed by the chairman of Coal India Limited. The review committee is board of directors, as per the rule 37 of the standing CDA rules. I prefer the
appellate authority is the chairman.
Appellate authority is the chairman.
So the first appeal and second appeal, the appeal number 1 and appeal number 2 are all pending.
All pending, but I have suffered the first one on. First part chapter is closed because already I suffered the punishment.
Not closed.
It has not adjudicated. What I said, it has not adjudicated till date. But my submission is this right now. I am going to retire on 31st July. I have paid for the representation, according to my Lord Justice Mantha, I have paid for the review. And they selected, they gave personal hearing and they will dispose it of. But that is not disposed of. Depending.
The appeal.
Review. Yes.
Review of which? Review before
against the order of appeal. Review against the order of appeal, second appeal. And in second case, that is dismissal. They upheld the dismissal order. Against of that appeal.
That appeal have been disposed of.
Appeal has been dismissed.
Okay. Dismissal also disposal.
Yes.
Okay. So both the appeal have been dismissed.
First appeal is still pending. That is not there. That is not disposed but dismissed.
Oh.
Second appeal is dismissed. Against of that, I have paid for the review. Dismissal was challenging. Here I am come to the High Court. My Lord Justice Mantha directed to prefer an appeal before the board of directors, except the chairman and managing director. I preferred the review petition, appeal before the board of directors. That is not given to me. That is pending till date. And right now I am going to retire superannuated 31st July. So my innocuous prayer is kindly give the direction to dispose of my appeal, review petition.
So whether this order was not there in the order of Justice Mantha?
Yes, I have.
So you file contempt. The Justice Mantha granted you liberty to file a review application, and Justice Mantha surely gave the direction upon the authority who will deal with the review application to dispose of the same within a certain period of time.
But time elapsed because
time elapsed. That means your remedy lies to contempt application.
Contempt application period cannot be done within 1 year. I have to file the contempt. That order was passed in the year of 2021. So I have right now the remedy to give the direction to dispose of my review. Only this.
So you dispose of the review?
Yes.
Your Lordship may see page 393, the order of the review which is in challenge here. I do not know what my learned friend is making submissions.
Oh. 390? So review has already been disposed of.
That is the subject matter of this writ petition.
You what?
Kindly come to 394.
393 is the review.
393.
Oh, that is the review filed before this court.
Yes.
Huh?
Delimited.
Yes. And your lordship may see.
May I
then
place it?
page
May I
243.
place it? 393.
You come to 394, what you are saying. The review application of the petitioner against the order of appellate authority shall be considered by the board of director afresh. The board shall consider the representation of the petitioner dated such and such. The final order
The chairman
will be
shall
passed
not.
in review, may be communicated.
No, your lordship, that has been disposed of. I'll show you, lordship. That is the perhaps.
However, no time has been, there was no time.
And they have taken the juice from that because there is no time.
Therefore, a learned advocate, a learned counsel of the court. Therefore, the second appeal, which was prepared challenging the order of dismissal, okay, was decided against him. He filed an application for review. The court directed that board of directors you dispose of the review petition.
Yes.
Filed by Sadasha. That review petition which is pending before the board of directors
till date,
whether has been disposed of or not.
Your lordship, it has been disposed of. Your lordship,
Where
it
is that order?
Your lordship, it would
They have to
appear.
give me one consent that my review petition has been disposed.
Your lordship,
where is that order?
Your lordship may grant me time till tomorrow. It is there. It is there. It has been done. The order which was there in the appeal has been upheld in the review again.
That is the order of dismissal, my lord. That is the order of dismissal upheld in the appeal. But there is the provision thereafter. Clause 37 of the CDA rules, 1968, there is a provision of appeal. My Lord Justice Mantha has elaborately discussed regarding the contention of the review. Against of the review application is pending.
Okay, one by one, Mr. Whether the review petition has been disposed of in compliance with the order of Justice Mantha or not?
Not.
That is the first question. Let the court find out its answer. Then we will go make a further submission. Here you are saying, claiming that it has not been.
Kindly come to 403.
It has not been disposed of. Your learned friend is saying, no, it has been disposed of.
Kindly come to 403.
Contradicted statement.
Kindly come to page 403.
Your name is B.V. Ramanaya. Ramanaya. Senior manager.
Senior manager.
You are Mr. Kedia.
Your lordship.
So, Mr. Kedia, there is no order.
Your lordship, my apologies, your lordship. I was not really ready for.
So, disposed of the review application.
Yes, only this I might pray.
I think neither of our go into the deep of this into the merit.
Dismiss Kuruga.
At this stage at least.
They may be dismiss my application, but they will take the steps.
Yes. You disposed of the petition.
Lordship, may kindly bear with me. It's at page 319.
319.
That is the only my lord, the appeal, order of the appeal that upheld the they have dismissal order. Kindly come to my lord, page 324.
It was passed by company secretary.
No, no, Your Lordship.
Board of directors.
Board of directors has not passed any order.
Your Lordship, it is by the board.
That is the
As
appeal.
a company secretary, M. Vishwanathan.
Yes, upheld.
Appeal of
Because,
what?
Your Lordship, this is pursuant to
Appeal of what? My
Mantha's
appeal.
order. My learned friend wants to make a fresh representation that can be done.
No, why representation?
Okay, what is the date of the order passed by the Justice Mantha?
My lord Justice Mantha passed an order, my lord, 378. My lord, February 18, 2021. Started from 378, my lord. It's come to end, my lord.
18th February 2022. What is
2021.
that order?
2021.
2022.
No, 378.
Where is the page? Page you.
378.
One review petition was filed. Review petition was filed by whom?
Review petition filed by me.
By Cole. Oh, before the. Yeah.
393 বলছে।
Yes.
393 পরে ওটাই 383.
উনি ওটাই খুঁজছেন।
Review was dismissed.
No, Your Lordship, there was a direction to consider and then Coal India considered.
Review was allowed. It has been disposed of.
No, my lord.
Come to page 24. 324. Sorry, 324. The board of director will not, the order passed by the board of director will not be communicated. Company secretary on behalf of the board of director communicated the decision of the board of director to you. And that is 324.
Kindly see the order where they have given the personal hearing.
That is another aspect of
That is the aspect.
You don't do
because,
it.
Because, my lord, that is the contention of my lord Justice Mantha, that they will not only dispose of my application, but they have to give me the
very hard.
hearing.
Your Lordship may
This is
see
the hearing.
It is very hard to deal.
Your Lordship may see the first
My lord,
paragraph.
claiming that the board of director did not dispose of your review petition as per the direction of Justice Mantha. Court took the trouble to find out that
Kindly come
yes,
to my
it
lord.
was disposed of.
Kindly come to my lord.
Now you are taking no opportunity of hearing was given.
I have
Hey,
taken- No, that is the second plea. First plea is this, kindly come to 403.
So you such a way you are trying to from the very beginning or presenting the case so that a simple matter, only a simple direction upon the board of directors that you dispose of the review petition in compliance with the order passed by a coordinate bench of this court. Subsequently, as and when is pointed out, court finds
Apart from this,
that your
this.
review petition has been disposed of.
Apart from this, subject to my lord.
So now the task now the court is to find out whether the order is justified or not.
Not only that, it is a board of director for review, but there is another provision for appeal. I have also preferred the appeal before the President of India, because if any order passed by the chairman Coal India Limited, the appellate authority is the President of India. I have preferred the appeal. Kindly come to page 413. That is also not disposed of. My lord, there is two options. First of option is this, either where to go. Either I have preferred appeal or I have to prefer review. If they said review is disposed of, but the review is disposed of, not giving any to me. But thereafter, I have preferred appeal before the President of India. And he is the appellate authority of CMD Coal India Limited. That is not disposed of. Only this consideration can give the direction in conscience of the Board of Directors or Coal India Chairman to dispose my appeal. Only this I want, innocuous fair, because this matter is hold merits. But right now, my client has no time. Because
that will serve your purpose.
That will serve my purpose, so that I will have the.
It is according to you, your perception. It is.
Yes, because it is my pleasure that I know.
So let us arrange the sequence of events. Initially, one disciplinary proceedings was initiated. The set was concluded, and a final order was passed. A punishment was passed. There was a reduction of pay.
Major punishment.
Major punishment. Okay. Now you prepared an appeal.
Yes.
The appeal was
not disposed.
Was not disposed of. During pendency of this appeal, the authority decided no.
No, during pendency, not pendency.
Such punishment is not sufficient. Here,
no, my lord. That is, I am.
Here, as I have understood, I
am assisting, my lord, because during pendency not, because when I suffered already the punishment.
Yes, you suffered the punishment for 1 year for a specific, that after 1 year they concluded no, this punishment is not sufficient. So they took steps to enhance the punishment.
Yes.
Again, they issued a so-called notice.
Yes. On the basis of self-same charge sheet.
Okay, self-same charge sheet. And initiated a fresh proceedings.
No.
Or took steps to enhance. To enhance the punishment.
Yes. Step means one so-called notice.
One so-called.
And against of that, I have paid for my reply. That reply is not disposed of. But they have issued the dismissal order to me during pendency of the reply of a so-called notice.
So it would be presumed that your reply they found unsatisfactory.
They have to give the reason.
And hence they enhance the punishment and ultimately dismissed you from service.
My lord, my submit to losses.
Leave the habit of uttering word in every moment. Here, the court is to understand the problem first. If you want to get order, the court before whom you are appearing, he is to understand the word.
My lord.
So they enhanced the punishment. The dismissal order was passed. You prepared a statutory appeal. Okay. The appeal was decided against you.
Not decided.
Appeal was disposed of?
No, because second appellate authority order was passed by the CMD Coal India and appellate authority President of India. I have preferred the appeal before the President of India. That is not disposed of.
The first appeal which you prepared challenging the order of reduction of pay, forget about the same. Keep it aside for the time being. Okay. The second appeal which was filed challenging the order of dismissal has been disposed of?
No.
Huh?
No.
Unless it is disposed of.
Against the order of dismissal, I preferred the appeal before the appellate authority of Coal India Chairman. That is the President of India. That is not disposed of. Let them say.
I do not know what appeal can lie before the
If
President.
the appeal is not disposed of, whether any question of review will come. Justice Mantha will give the direction that you dispose of the review petition. The question of filing review petition will not come.
If my lord satisfied, if my lord complete my lord, then I shall say. If my lord complete my lord, then I shall say. I shall make.
Yes, give answer.
Lordship, may I say one thing? If my learned friend still wants to make a representation, he can make.
Before?
It may, before the Board of Directors,
Board of Directors is the ultimate authority?
Yes. If he goes before the President, then my role is over. Then he has to implead the Union of India and fight with the Union. But if he wants the Coal India to consider, He should say he will make a representation and I'll consider it. But he cannot say that I have not considered something which was passed in a lordship's order.
Court is unable to know the fact, real fact. Actually, outline of the fact, not at all the fact in details. So thereafter, admittedly, both the appeals are pending for consideration, final consideration.
No, no, Your Lordship.
Bow down, I bow down.
No, no, Your Lordship, when the second appeal was heard, it was decided against my learned friend. They preferred the review petition. And in the review, Lordship, Justice Mantha had directed for a review of that order. The review was also done, and that is in
When
charge.
appeal disposed of, appellate authorities against CMD is the President of India. As per
My
the
learned
statute.
friend can show which
Okay, you will.
provision for President of India.
Yes.
You will again confuse. Where is the total fact? That order recorded total fact? Order
Kindly come to
passed by Justice
kindly
Mantha?
Kindly comes to the list of date.
Okay, you will confuse.
List of date.
You are unable to convince, and then your only remedy is
The review order
confuse
which
the
was
judge.
passed by Coal India, it records all the facts at 319.
And you are trying to take a order for the direction to upon the board of directors to dispose of the review. Both of you have not read the brief. A simple information whether the appeal preferred by the petitioner challenging the order of dismissal from service has been disposed of or not. He is claiming that it has not been disposed of. So question is not clear to the court. If the appeal is not disposed of, how the question of filing review petition can come? Who will dispose of review? Actually, board of director is not the disciplinary authority. So dismissal order was passed either by chairman, secretary, such and such. Against whom an appeal is there?
Yes, Your Lordship.
Who is the disciplinary authority here?
Your Lordship, it would be the concerned subsidiary. I think Western Coalfield Limited.
No.
Your Lordship,
You have not read, Mr. Kar.
No, Your Lordship, I'll admit
The
that.
person is senior manager, working as a senior manager level,
Lordship.
as senior manager at the time of initiation of the proceedings. So who will be his disciplinary authority?
CMD of the residuary wing.
Subsidiary.
That is subsidiary.
Who will be?
Your Lordship, the
You have not seen.
No, Your Lordship, CMD of the subsidiary, not of Coal India Limited, the CMD of the subsidiary. He was working in
So
Western
CMD.
of
CMD
Western
means
Coalfield Limited.
CMD
Chairman and managing director
chairman and managing director would be the disciplinary authority
of the subsidiary.
of the subsidiary.
Subsidiary.
Okay. So the order of dismissal or order of reduction was passed by the chairman and MD. The appeal lies to whom?
The chairman and managing director of Coal India Limited and the board of
So appeal lies to chairman and managing director of Coal India. So two appeal at two different stages are preferred. One challenging the reduction of pay, another challenging the dismissal of order. So whether these two appeals have been disposed of or not. He is claiming that first appeal has not been disposed of. Now, for the sake of argument, it is assumed that after passing the dismissal order, the first appeal has become infructuous. Because the person who has dismissed, the question of reduction has become irrelevant. He has dismissed, he has lost everything. Now, whether the appeal challenging the order of dismissal from service has been disposed of or not. If it is not disposed of, so how question of review petition, filing review petition is coming? comes. You read. You are not ready. File the bottom. Petition. Mr. Shedia.
Your Lordship, I'll give the page number. The order date was 15/1/2021 / 02/02/2021. That is the dismissal order, and that was the subject matter of the review, as well as the review by the Board of Directors subsequently. Your Lordship may see page 324, the review order. It records that finding.
Who Board of Director? Now, Chairman or Managing Director is the appellate authority. So whether there is a provision of revision in the relevant rules?
No, Your Lordship. And my
No
Lordship
division.
says that yes, it should go to the President of India. Because, Your Lordship, the chairman had decided, it came up in review before Honorable Justice Mantha. His Lordship referred that it should be reviewed.
So he filed a review application addressed to whom? Chairman. Review petition you file addressing to whom? Before whom?
Board of Directors.
Board of Directors. Have you filed affidavit in opposition?
Your Lordship, we have.
My lord, the matter firstly came before my lord Justice Amrita Sinha. His lordship was directed to prefer affidavit and reply, but they have not handed me any affidavit in opposition.
So you file affidavit in opposition. Bring all the documents.
And also, my lord, subject
And file a list of dates, any of you,
Yes, Your Lordship, because
on the date of final hearing.
My lord,
Your Lordship.
also, my lord, subject to
Huh?
also, my lord, subject to kind permission. It is a substantial question of law, because when the CMD of WCL as a disciplining authority pass the major punishment against me, then I have to pay for appeal before the appellate authority. Now, CMD of the subsidiaries, CMD Coal India is the appellate authority. Now, CMD Coal India appellate authority, I pay for appeal is not disposed of. Now, secondly, that appellate authority can issue show cause notice as a disciplining authority to enhance the punishment and dismiss from
That would be addressed at the time of final hearing.
I sir.
That would be addressed. Okay. And now the situation is such, even if appeal is pending, since the Board of Directors, a superior authority has already taken a decision whether the appellate authority will overturn the same or overrule the same. So actually impugned here, the order passed on review petition.
Your Lordship, that is the
My lord,
prayer.
also, my lord,
Huh?
no. My lord Justice also hold, my lord Justice Mantha, that CMD also one board of director. CMD is also one board of director. It is held by my lord Justice Mantha. Against of that order, they have not preferred any appeal.
Okay. So you file affidavit opposition?
Lordship, I have filed the court officer is searching if it is there on record.
Affidavit in opposition.
Madam, sir.
Okay, that's the letter.
File affidavit in opposition and reply.
আমাদের দিয়েছে affidavit.
So affidavit opposition they have filed. You have not filed any reply. Okay.
I have to check up.
So file reply.
Let them give a copy
Yeah.
again.
Huh?
Let them give a
I'll
copy.
give a copy again.
Affidavit in reply is there one. You find what is this? It is account.
পয়সা এখন বাঁচবে ব্যাকসিটা দেখি কোন পেজ আছে
Okay, you check the brief, you take also instruction. Okay, I am adjourn the matter and fixing on another date. If the reply is not filed, you file on that date and exchange it. So reply is there. So you come prepare a list of date. You also prepare list of date so that the pages can be easily located. Okay, that this is the you have heard entire matter, 2 appeals pending, whether the appeal has been disposed of or not, or how the question of filing review petition before the board of director came. Entire matter you. So heard the learned advocate appealing for the respective party list the matter for further consideration. দুটো নয় এমনি পাঁচটা on 25th
as part heard.
No, not part.
Otherwise, my lord, may I get my lord flag in the poll?
It will appear on that date. Get yourself ready. Today hearing could have been concluded. At least. You are not ready, what can be done?
Retain the position, my lord.
Today I have given sufficient time.
Retain the position.
It will retain in the position. On that date it will appear, don't worry.
Item number 34.
Not today.
In this matter, the state had already filed an opposition in this matter. I am filing my reply.
No, keep it. On that date you will file. Okay.
I will serve, sir. I have served it, my lord.
No, today order. What order?
Only reply file, my lord. Fix the next date, my lord.
On the next date, not today.
Lord, do you kindly record an order? Records an order. File.
36.
Not today. You are for the petitioner. Your other side is not there. Not today.
37.
37, I am also appealing for the petition.
Only state. No, whether except there are any other parties.
There was a direction for filing opposition. Malad, they did not, till date, they did not file any opposition. Malad, direction has been given, Malad, on long back. Malad, already issue decided by this division bench. The petitioner joined as a LDC, Malad, and District Judge Malda. Subsequently, she transferred.
Who is from the High Court administration?
Earlier occasion, all appeared and direction has been given to file opposition.
Okay, today you have adopted resolution. What can be done?
Not today.
Not today. Petitioner?
Sir, 39, 30, 39, 40 be taken up together. Mr. Dipendu Chatterjee is appearing on behalf of the petitioner. Mr. Dipendu Chatterjee is appearing on behalf of the petitioner with regard to item number 38 and 39. My lord, I am also taking the same point of the matter, Mr. Chatterjee. So these three matters can be taken up together as because there are direction also, my lord Justice Chief.
Not today. Why?
Yes, can
Not
it be
today. Yes.
Oh, my lord, my learned friend is asking to record an order for his purpose.
Okay, I have understood today. All benefit. Benefit of not to pass any adverse order and again recording double benefit would not be. Yes, next criminal matter whether
41.
My lord, I am appearing for, my lord. Not today.
not today.
42.
My lord, in 42, my lord, Mr. Bhunya is appearing for the petitioner, my lord. He is suffering from some health issue, my lord. So, on behalf of Mr. Bhunya, I pray for not this week, my lord.
Not this week.
My lord, I am instructed by his
Okay, not this week.
grateful, my lord.
Yes. তাহলে এবার আপনার 58 হ্যাঁ মান্থলি লিস্ট থেকে আসতে হবে আর কি করব আপনি দেখে নিন শিখে নিন আপনি শিখে নিন দাগ দেবো না হ্যাঁ হ্যাঁ দাগ হ্যাঁ
Item number 58.
ওকে নট টুডে হ্যাঁ দেখে যান
59, 60, 1, 62, 3, 64, 5, 66, 67.
I have informed her. She is eager to do the matter. So let it be pass over so that it can be.
পাস ওভার হয়ে যায়
I'm coming with her. She was waiting for that.
item number
67.
Okay, let's see what can be done. 67 টা মার্ক দিয়ে রেখে দিন তবে বাকি দেখে যান
Pass over.
68.
Yes, I am coming with that.
My Lordship, in this matter, I am for the petitioner in item number 68. My Lordship, we have came with a notification that for the vote of act, regulations and rules which have been challenged, my Lordship, in that case, we need to made a service to the Attorney General. My Lordship, let an order be passed so that we can made a service to the Attorney General, my Lordship.
We have challenged the virus.
Yes, my Lordship, the rules, we have challenged the rules and regulations in this matter.
Which rules and regulations?
My Lordship, it's regarding the legal metrology.
Huh?
Legal metrology.
Okay, not today. You come on that date.
My Lordship,
mention
later,
this matter.
Okay,
Okay, today is just not today. Yes.
grateful, my Lordship.
69. 71.
And for the petitioner in this matter.
71.
be your lordship's pleasure to fix a time for this. It won't take much time.
It is motion, it would be taken up. Don't worry, it would be taken up. Just
Can it be placed in the regular?
in this week, it may be taken up.
Can it be?
56 item up to motion 56 has already been.
There are many matters in the.
Yes, so any day it should be taken up. আপনি মোশন গুলো আগে দিয়ে দিন, নামিয়ে দিই, বুঝতে পেরেছেন? মোশনটা দিয়ে দিন। লট ধরে কত 58 20টা ম্যাটার তো কতক্ষণ লাগে? না না, কোথায় লট ওয়ান লট?
I am coming with hands. Because it's my item. 71.
What is your other side? Where is your other side?
I do not know. I have sought my affidavit of service.
Oh, not today, not today.
Yes, my lord, at least a affidavit of service and one order, short order, the petitioner will serve again.
You serve. You serve.
Yeah, my lord, affidavit of service at least, my lord.
No, not in this way. Okay. In absence of other side, no order.
No adverse order, I am praying, my lord. No adverse order.
You served. Who has prevented you to from serving the copy? You served on that date order. Yes, 67টা দেখুন তো কি বলছি। 67টা all parties are present. All parties are present. দেখি 67টা দেখি।
67. He was waiting.
Okay, let's see. 67.
If Mr. Bishwas is there, he ensures that I am present.
I'm
running from here to there. Well,
petitioner
only
election 14.
Subdivisional officer is there. That means state. No, how?
I'm appearing for the State Election Commission, Lordship.
State. But it is admitted fact. If your lordship kindly take care of
Chief Electoral Officer.
Yes, he is appearing.
Respondent number 1.
Chief Electoral Officer, your Lordship, always comes under the State Election Commission.
Yes.
Yes, but during the time of election, they all come under the State Election Commission. But if a service has been rendered and a payment has not been made, then I believe that state should be the responding authority. But here,
Yes.
I have not gone through the brief, but here that my learned friend has said that this letter has been forwarded to the State Election Commission. So then in that case, State Election Commission, let me find out whether they have remunerated or give him, give yes.
Let her kindly take page 14. It is admitted fact. Page 14. I was engaged. Tell me another date. I am placing just 2 minutes. Page 14. It is, might have got it.
Yes.
I am certified that the Sandeep Karak, my client, such and such, worked as vendor of data entry work, such and such, office, subdivisional officer, confirm such and such format. Now I have made a bill of 11 lakhs odd for my work. And out of that 3.64 lakhs has been paid to. Rest of the amount might kindly come to. I have made the bill and then page P5, page 18.
No, you executed certain work allotted to you by SDO Kharagpur. Maybe
Epic.
Maybe at that time of he is under the administrative control of the such and such. But financial matter, Chief Election Commission cannot take any responsibility.
All right. Next minute, kindly come to page.
So state of West Bengal is required to be passed.
Come to page 18. SDO already admitted that and thereafter made all these to district election officer,
district magistrate. Okay, so this is also state.
State is there. Let it be.
Have you served upon them?
Yes. Affidavit of service.
Who is appearing for the state? Actually, he is not the answer. answering respondent. Main answering respondent is the state.
Let it be under the heading any.
It will retain in the list any day.
But it is a monthly list. It is a monthly list.
No,
May not be called on.
don't okay. What?
Then your
Today it could have called on.
Your lordship
Any day.
Taking up after that matter.
Any day, even tomorrow can be taken up. This matter.
Let it be under supplementary.
It would be taken up. Don't worry. এই আপনি
Let it be in the
Okay.
So you are taking the.
কিন্তু কালকে তো একটা টপে রাখলেন সেটার পর দিয়ে দেবেন তাহলে হ্যাঁ সেটার পরে দিয়ে দেবেন মোশন গুলো শেষ করে দিন হ্যাঁ কটা আছে এই কটা আছে তো মোশন শেষ করে দিয়ে আপগ্রেডেড হেন যা আছে হ্যাঁ 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 lot one complete. Yes, tomorrow come tomorrow. You give notice to the representatives.
But one leave I am requiring. Let the chief electoral officer be made a party.
The chief electoral officer, but I will tell you, SEC takes care of elections during panchayats and municipalities. Chief electoral officer, which address he has given, 21 Netaji Subhas Road, Fairley Place, takes care under ECI. This office comes under ECI. তুমি কোন ইলেকশন সময় এপিক বানিয়েছে
10 থেকে
19 তো ওর মধ্যে কোন ইলেকশন অনেক ইলেকশন হতে পারে সেটা গভর্নমেন্ট ইস্যু করবে ঠিক আছে আমার I don't think your lordship I am a necessary party.
But let it be.
He is responsible to ensure so that election is done in transparent manner, in proper manner. Proper manner, but he is not concerned with the fund.
Yes.
Then he is the appropriate authority.
And even
I worked under
State is the authority.
SDO is under the state.
State is the authority because election is conducted from the state fund.
Yes.
State is the
Once
authority.
we release your lordship, once the state allocates funds to us for conducting elections, we give it to certain districts.
Yes, yes.
We disburse the funds.
Yes.
So once that headache is gone, then whom you are paying, whom you are not paying is not our headache. So this is it.
So you ensure the presence of state representative of the state. You take information who has been engaged in this on behalf of the state. You serve the notice that tomorrow this matter will be.
Let it be another one.
Same heading, same heading. Don't worry.
Not in the monthly list. Let it be on the same supplement.
Oh, okay. No matter. No matter. Okay. Yes.
I'm serving again. Get what it is.
আচ্ছা আমি করে দিন একটা হারতাল আচ্ছা হ্যাভিং হারতাল হ্যাভিং হারতাল
For the petitioner, I'm praying only.
Next.
I'm praying only not today.
Not today. Yes, not today. Not today.
7, 78.
এগুলো কি আলাদা আপডেটের ম্যাটার না আপসো কথা ডাকতে হবে না আপনি ডাকুন না ডেকে কেউ দেড়শো ফেরশো পর্যন্ত ডাকুন নাই কেউ তো
79, 80, 81.
Resolutions adopted by you, what can be done?
82, 84, 85.
85, my application. Your Lordship was pleased to, my Lord, pass order on 4th April 2025, directing the state respondents to file an affidavit in opposition, stating that the... Oh, sorry,
Okay, next.
86, 87, 88, 89, 90, 91, 92.
93.
93, 94, 95.
95. My lord, this matter I have been mentioning, my lord, for quite some time. My lord, the other side is still not here today, my lord. May I, my lord, place the facts, because, my lord, the writ petition will become infractuous now. And, my lord,
Writ petition has become infractuous.
because, my lord, out of 11 petitioners, my lord, 3 are only left, others have retired. And, my lord, this is a matter whereby, my lord, the merit panel, in which, my lord, the petitioners, my lord, was of the batch of 1998. In merit panel, petitioners were holders of higher positions. They had been given appointment letters at later dates after, my lord, filing of another writ petition, whereas the less meritorious candidates were given appointment letters on prior days, for which, my lord, there have been twofold deprivation, first in terms of salary, and second, my lord, in terms of pay fixation. And in the uniform, my lord, career progression scheme also, my lord, they have been deprived. The anomaly committee had been created, which said that yes, since they were from the same batch, my lord, executives, they are required to be, my lord, given at par, I mean, the benefit. Yes, my lord, on that regard, we have been making representations, my lord, for, my lord, years. Then the respondent authority had replied, no, it will be according to the gradation list. However, your lordship will find in the first order, which was passed by her ladyship, my lord, Honorable Justice Lopita Banerjee, it has been indicated, and they were asked to give the reasons through a report that why appointment letters were issued on later dates to us. Like after 2.5 years, we were issued, my lord, the appointment letters, for which we are now lagging in every aspect, my lord. However, in the report, my lord, they say that because of the police verification, which was done on later dates, we have been given appointment letters on later dates. My lord, we will show from the document itself, on the same year, police verification was done for all the candidates. However, my lord, the appointment letters were not issued. So, my lord, they could not give any proper grounds in their report. We have filed the exception also. And they are not coming for the last various occasions. My lord, before my lord's determination, it was with Honorable Justice Hiranma Bhattacharya. My lord, they did not appear. And in the meantime, 7 of them...
Today is the...
Only, my lord, since this is in the upgraded list, my lord, it was in the daily list. It went to...
Keep watch on the list.
In the monthly list, my lord.
Watch on the list. Okay, it would be placed at any day.
My lord, kindly,
at
my
the
lord,
top.
my lord, kindly, my lord, I am really sorry for bothering, my lord, but my lord, kindly fix this matter.
No, it can be given retrospectively. Oh,
no, my lord,
since the urgent matter will be given priority according to the urgency.
Lordship.
Not at the instances of any person.
My lord,
your client is creating pressure upon me. That means upon you. That means the matter has become
extreme
urgent.
pressure, my lord. This is the difficulty. I am unable to make them understand.
It can be given retrospectively. If they are entitled to give any financial benefit, it can be given with retrospective effect.
My lord.
Huh? So ask them to
work
for some time.
This matter, because it was there in the daily list only, my lord. It then went down in the
placed. It would be placed any day at the top. Upgraded matter, then all matters kindly kindly follow the list, keep watch on the list. All matter are being reshuffled.
My lord,
On
upgraded
the-
matters, my lord, it is under upgraded matter only, but it is
Already updated from
but it is gradually going down.
your matter was most probably at the bottom of the list. Upgraded.
No, it was
Yes.
at item 20 and now, my lord, it went to 95.
So it would be
In
placed.
daily list, it was appearing.
Okay, it would be placed any day. It would be taken up for hearing.
Only
Date
my
yourself-
lord, only requesting, let it come in the daily list, my lord, under
No, no,
updated
no,
matter.
no, no.
My lord, kindly, my lord.
No, I do not find it so urgency that immediate intervention of this court is required.
Because my lord,
Okay, call the list. Call the list. Call the list. Next.
Sir, may I serve one notice if my lord kindly passes one order, like I will serve.
No, not today.
Notice.
Not today.
My
96, 97, 97, 98,
98, my lord, my application.
98 to 105.
On 4th April, my lord, 2025, your lordship directed the state respondents to file affidavit in opposition stating that some of the employees retired subsequently. They have been, my lord, given their services has been approved by the director of local body, and that's why they have been given pension. But on the basis of that, the order which has been passed by your lordship directing the state respondents, till date in this matter, no such affidavit has yet been filed.
Okay, when the matter will be taken up for hearing, then you will say, okay, and if the court finds that there is scope of passing, dispose of the matter without waiting for their affidavit, the matter will be disposed of.
8 to 105, my lord. These matters are identical and my lord will cover one order, my lord, to be passed by the
Okay. On that date, today you have adopted a resolution. Okay. On that date, you place the matter. If it is found that without waiting, again the excuse repetition, without waiting for their affidavit, the matter can be disposed of. It could be disposed of. Don't worry.
My lord, the matter
Okay.
will be placed in the supplementary list or my lord,
Huh?
the daily list or
No. It would be placed in the daily list. Keep watch on the list. Yes.
106, 107,
Hmm.
108, 109,
Lordship, I am for the respondent and
109,
HMC 109.
Okay,
led
not today,
by-
not today.
110, 111, 112, 113, 114, 115, 116, 117, 118, 119, 120, 121, 122, 123, 124, 125, 126,
75, my lord.
25, 125, 125, 125, 75, না 125, হয়ে গেছে 126, 127, 128, 129, 130,
এবার কি করে দেবেন যে পেজনে দেখে দেবেন নাকি? আচ্ছা ঠিক আছে, আপনি ডাকুন পর্যন্ত। ঠিক আছে, আপনি এই 145 পর্যন্ত ডাকুন, দেখি কি হয়।
133, 134, 35, 136, 137, 138, 139, 140, 141, 142, 143, 144, 145,
My lord, with regard to item number 79, my lord, the matter was called on. I was not there. My lord, if it could be taken up tomorrow again, my lord.
Why?
79, my lord. My mutation is pending from 20.
Huh?
My mutation is pending from 2017, my lord.
Many things is pending since long.
Thank you, my lord.
Why special
No, my lord.
Treatment shall be
No,
given
no
to your
special
matter.
treatment, my lord.
So?
Let that matter be taken up tomorrow again, my lord.
How priority and precedence should be given to your matter over the other matter?
I am not asking for any precedence, my lord.
There is a judgment of the Supreme. That is, it would be an unequal treatment.
My lord, if it could be written in his
Huh?
petition, if it could written in his
That is violation of the fundamental rights of God. Okay.
my lord, it will be taken up tomorrow, my lord. That's what.
Okay. You keep on watch on the list. It would be reshuffled. One day upgraded matter, I have again saying upgraded matter will be placed. One day returnable matters, one day parted matter will be assigned matter. Everything. You keep watch on the list. Okay, I have certain motions. After exhausting the motor matter, the matter will be reshuffled. Already from 7, the some matter have been reshuffled. So that everyone can get the chance to place their case. I am trying as 700 matters I have in the list. Okay, I am trying what more I can do. You keep one on the watch on the list.
No, this is 79 years old lady. I don't not see claiming
pension matter, pension. So it would come under the heading pension matter.
I have also mentioned
one matter has been grouped, categorized as pension matter and placed under the heading pension matter.
I have also mentioned this matter with notice to the other
Hey, apni owner matter the pension matter. Whether that boy matter is pension matter? No.
Item number 231, Lordship, which is a senior citizen matter, Lordship. 82 years old, land acquisition, Lordship, no payment, nothing. He is praying for, Lordship, 2014 Act acquisition proceedings.
Oh, didn't to senior citizen matter. Senior citizen matter. Senior citizen একটা group করে দেওয়া হবে নাকি? Once Supreme Court directed that though our senior citizen matter is to be disposed of expeditiously. Once, way back.
Only one thing, my lord. Items in the monthlies, those have been called on. My lord, 79, my lord, I was appearing for petitioner. Would we retain its position for tomorrow?
Or not tomorrow. I cannot say tomorrow. Okay. You give some time to the court. I am trying to reshuffle the matter so that all the litigants can at least present their case. And as per my ability, I can touch. Okay, your matter is appearing under the heading upgraded matter. That means already upgraded. One day you will find that it is appearing at the top of the list, supplementary list. Okay, do your matter on that day. If your petitioner is senior citizen or pension matter.
So, my lord, what happened, my lord, my family deed, my lord, which I have purchased, my lord, I applied for a certified copy before the office of registry. My lord, they are not supplying the same to me. My lord, I am before on this honorable court seeking a direction upon them to supply me my deed, which I am entitled.
What is the cause of withholding the deed?
Yes, my lord, they say, my lord, as you have purchased from XYZ, so my lord, XYZ has not applied for certified copy, therefore I will not give. My lord, very absurd reason has been given.
And you are?
I am the purchaser.
You are purchaser.
My lord, I shall.
You are seeking certified copy.
Certified copy.
I don't know. Yeah. Okay, in presence of state, it would be, yeah.
May be permitted one. Serial number 537 of monthly list, July 2025. My lord,
if you want to get any matter upgraded, then you have to mention upon notice to your other side. Mention, you have to give a notice intimating this, the matter will be mentioned for upgradation either on Thursday or on Monday. You mention this matter. If you can satisfy the court that yes, immediate intervention of this court is required, the matter would be upgraded. Don't worry, you give notice today, come tomorrow.
Yes.
In the morning, okay? Yes.
Please order item number 43.
My lord, I am Dev Chatterjee is appearing for the respondent, my lord. He has not come to court for the resolution, my lord. I am paying for only 1 day accommodation. Kindly fix this matter on tomorrow, my lord. As instructed me to pay before your lordship, my lord.
Hello,
Tomorrow.
on 23, my lord, 23rd, my lord. This is my lord.
Have you taken information? 23rd is available. Tomorrow, at 2 p.m., fixed up to 1st August. If you want the matter to be fixed at 2 p.m., then you have to go on 4th August.
4th August.
As second 2 p.m. matter,
My lord, before 2 p.m. we have 12টা
অর্জন সাহেব কাল পরশু হবে না তো কম 2 p.m. কোনটা আছে
My lord, you also may remember that this is a review matter.
yes. ওইসব ঝামেলা
These substantial question law have been framed, my lord, and that answer is in my favor. And but the court may have decided and another not framing substantial question of law travel beyond the scope and ambit.
Yes.
The court held that the court cannot go cannot travel beyond the
third case has been made out.
and third case has been made out, which has been answered in my favor. The trial court judgment in my favor. This appellant did not prefer any first appeal. Trial court held that he is a trespasser, and appeal court held in my favor that he is a trespasser, and eviction decree was passed. And then second appeal, for the first time, they did not challenge the trial court order, only challenge the first appellate court order. And that 3 substantial questions have been framed, and all 3 substantial questions are decided in my favor. But in deciding the substantial question of law, court on the ground of another
and made out a third case
made out,
ultimately decided against you.
Decided that without investigation,
yes.
without investigation, I cannot get any degree for eviction. As I am a co-sharer, I have a 50% share, so I have not entitled to get a degree without ascertaining by through investigation. Even this that is to be correct. Then the court cannot set aside. Court can direct. The court can send the matter on demand that you appoint an investigation commission. Survey post advocate commissioner will be appointed, and after that, if the survey post commissioner finds that he is in the position of the suit property, that I am entitled to get degree. At best, that can be.
Who prefer the second appeal?
Second appeal, trespasser. Even number 3.
Appeal court order in favor, in your favor.
First appeal in the trial court, my lord decided that he is a rank trespasser. But the trial court.
So if the intervention or appointment of survey commissioner is required, that is the question of fact.
Question of fact that cannot be decided. The Supreme Court held that.
Okay, when I shall apply my mind to the matter, I shall consider.
This is 20.
But now I am thinking, when? Second 2 p.m. matter. 25th July. Second 2 p.m. matter. Oh, we have got first 2 p.m. matter.
24th, then my lord, 24th.
No, 24th most probably. Already there is 2 p.m. matters. 27, 2 p.m. available.
27.
So any order is required to be passed for material instruction or anything. Mr. Dotto? Needed. Heard the learned advocate appearing for the respective party. But Okay, 24th. 24th, but it should be 3rd to be a matter.
But 24th or 23rd, my lord, any day, my lord.
Be a matter. But your learned friend has already get their matter fixed on that Act 24th. Yes, 24th. 24th. Ask your senior to come on that date.
As your lordship did.
Yes.
Deeply obliged.
No, on 25th, my other two matters have been already fixed.
Oh, in other court. Okay, okay, come on that day.
Deeply obliged.
Yes.
Item number 44. I appear for the four petitioners.
Oh, that matter. So that matter, what is your instruction? Whether you will accept their proposal? Huh?
No, I cannot say.
So they will raise the issue of maintainability first. And I am to address this issue first.
No, সেটাই তো বলছি, sir. Well, why I am telling you, Lordship, I will see paragraph 15 of my writ petition.
They are inclined to
They have given a
extend such benefit to all except who retired in the year 2014.
Yes, 2014. Well, can you see paragraph 15, page 9? Their date of retirement.
Paragraph.
As per their proposal, we will be entitled to get the arrears for the preceding 5 years from the date of filing of the writ petition. Writ petition was filed.
Paragraph 15 of the writ petition.
15 of the writ petition. We have given the list dates of retirement. Normal superannuation.
Yes.
So, my lord, preceding 5 years from 2021, the year of filing the writ petition, it comes from the arrears calculation will be calculated from 2016. If it is from 2016, then the person writ petitioner who retired in 2014 he or she should not get any cut.
Yes, except 2014 will not be able to give.
The first one, 30th October 2018, you will be getting 2 years. 30th June 2017, you will be getting 1 year.
3 years preceding the date of institution of the proceedings on earlier date. Mr. Gupta stated, now you consider whether you will accept or not.
Charity, but we will not get any further. If it is 3 years or 5 years. Nothing. Time consider. That is why I am showing the date of retirement. Not get anything. Because we retired 2018, 3 years from 2021 comes to back to 2 years, 3 years, 18. Then 18, he or she will not get anything. 14 will not get anything. 17 get anything. 19 he may get something.
No.
Well, our date of retirement and what will be our amount of arrears for the preceding 3 years from the date of filing of the writ petition, they get this proposal.
Not that, Mr. Singh, they are saying that who retired most about 3 years preceding the date of institution of this proceeding. This writ petition was instituted in 2021. So 3 years would be 18. Now who retired up to proceedings 3 years, situated for a period of And court has recorded that was retired. That means this person, except the person who retired in 2014, all this person will get benefit of two revision of pay of 1998 and 2009 for a period of 5 years. 5 years they will get.
The areas calculation will be calculated from the date. Areas between the date of filing. Areas will be calculated for the from 3 years preceding the date of filing. 21
No.
3 years preceding comes to 2018.
But that is it.
2 years plus additional 2 years.
2 years.
5 years.
From which period it would be calculated?
1st of July 2021, the date of filing of the petition. You go back 5 years, 3
Yes.
years.
Yes.
It comes to 16th of July 21st of July.
16.
Now, whoever had retired prior to 16 will not get it. Now, who has retired up 16 or afterwards, he will get benefit for the period from 21st July 2016 to the actual date of 17, 18.
Only 1 year.
Now it is clear.
Therefore, only 1 year. One will not get anything. Who has retired?
So who retired in 2017, he will get only for 1 year.
The difficulty has been created by sense clients themselves. They had been waiting. They are fence sitters, waiting for. Why did they file the petition in 2021? After retirement in 2014, 2017, 18, they filed the petition in 2021, looking at the other and the results there. They have been fence sitters. We have raised that objection for the purpose of trying to convince your lordship that the petition is not maintainable. Because they are fence sitters. Judgments on that. We are not taking that job.
If your lordship
opinion box, he will get it.
It's really sincere and honest submission. I should say honest.
But in any event, they had waited. They had waited till 2021, having retired in 2014, 16, 17, and 19. Filed the petition in 2021. Therefore, they are themselves responsible for this fate.
As if, and had we filed the petition in right time, they would have allowed us the benefit of proper rules. As if.
In any case,
I'm grateful.
The Honorable Division Bench has stressed the period for the grant of the benefit. Asking us, my lord, to take a reasonable stand. And we have to approach the board of directors of this organization for the purpose of making this concession. That yes, we will go beyond 3 years. We will pay them up to 2 years more as the court desired. And that is how, my lord, this was arrived at. And the division bench passed the order, noting that the very fair stand has been taken by entities.
Whether that stand has been accepted by the division bench?
Yes. Your lordship possibly has got the order of the division bench.
Whether it has been annexed? Yes, I have got the one order passed in math. Yes, the application.
2025.
A page? Affidavit of opposition. It has been annexed with affidavit of opposition.
Order is separately. I will not supply this for 16 May 2025. Let's finally take this one. Your lordship will kindly come to the second page.
We are of the view that NTPC has taken a fair stand. That means the division bench has accepted the stand.
Of course, yes. Now we are kindly see the fifth line at page 2.
A page?
It's to fifth line.
Yes.
On top. Salary area would become payable for the period of 5 years, comprising arrears for 3 years prior to the month and year of filing of the return, along with arrear for an additional 2 years with effect from 2016. Back 2016. NTPC has taken a fair step. Then we are kindly turn the page. Kindly come to page 3. He raised an additional prayer for provident fund. On that, we will kindly note paragraph 8 of this order. It will be open to the applicants to take appropriate steps in accordance with law with regard to the state decision of the Regional Provident Fund Commissioner Siliguri, etc. Siliguri Provident Fund Commissioner said they are not entirely. We are not going to this because we are Provident Fund Authority, a different authority, they will take their decision. That's why the division bench said this. They are at liberty to approach that authority or to take any action against their action. Now, next is finally come to paragraph 10. Just before paragraph 10, there is one line. However, if prayer is made for gratuity, then the paragraph 10 deals with that. Paragraph 10, NTPC shall consider whether any additional sum can be given to the fact that they have continuously worked for a considerable period of time and the children of the locality as well as staff of NTPC have been benefited by their service. We feel that considering the service rendered by them as a model employer, NTPC should consider the payment of a reasonable honorarium or additional amount, as the case may be, in the nature of gratuity. This is an additional benefit. We had no liability to pay gratuity to them because there is a previous judgment, previous round of litigation where this Honorable Court held that NTPC is not the employer in respect of the staff of that school. A separate local management committee, which is the employer. There is judgment on that. Now here, we did raise that point even. We say that all right, don't call it a gratuity. A sum in the nature of gratuity, we shall pay. Then the court records this.
So whether you will give such benefit to the present petitioner also?
The proposal for a year in the form of VRS under the Gujarat pattern or Gujarat formula. VRS. Then Gujarat pattern of VRS formula, and it has been specifically mentioned that the payment of the year or VRS will not debar the employee from getting their gratuity benefits. Specific provision is there. I can show it right now. Therefore, I made it clear that it is our hereditary entitlement right of getting gratuity. These are right to get it.
From whom?
Therefore, yes, no doubt from whom. There are instances I brought to the record that the employees, I mean the school staff, school staff, were paid gratuity by the NTPC.
Let my learned friend also be told this. Either he accepts the division bench benefit.
Yes.
If he doesn't, let us contest that.
Yes.
I am telling my I am not a
Because the division bench said that we are of the view that NTPC has taken a fair stand. That is acceptance of their stand by the Honorable Division Bench.
I am not a party in that question.
And I cannot go beyond that. Now, if you deny that I shall not accept such proposal, so you
petition where from my lord that appeal arose was filed by the teaching staff of the secondary section of the school. We are the primary staff of the primary teaching staff of the school. We are not empowering them.
Yes, I have. I most probably you heard, but then Mr. Bhattacharya appeared in this matter and raised the issue of constructive res judicata. That this point was raised or ought to have been raised in a writ petition or in a earlier round of litigation. I cannot recollect here and now. Earlier round of litigation. So we have to cross this hurdle first.
Yes.
But before this, since they have raised the issue of maintainability, so let them address first on this
On the
issue.
point of maintainability.
On the point of maintainability.
Maintainability, that is a res judicata.
Res judicata. Yes.
Let them.
Let them. Even court is find that yes, the writ petition is not maintainable on this ground, then there is no question to proceed further. Right? So, Mr.
Res judicata point, let them. On the point of maintainability, especially particularly on the point of res judicata.
Res judicata, yes. Such issue was raised most probably in earlier round of litigation.
Mr. Bhattacharya. Let them. I will answer. I am ready to answer. Is dealt with in the writ petition, that writ petition. Now, that judgment has not been disturbed in the division bench judgment as placed before your lordship.
So, whether you will submit first regarding the issue of maintainability, res judicata raised by you.
Maintainability not only from the point of res judicata, but also on the ground of fencing.
Their delay. Yes.
Fencing. They have been waiting for the outcome of the other pending proceeding, which are in 14, 17, 18, 19. They filed this petition 2021.
So the delay down also in additionally we will take. Yeah. So you argue?
If your lordship kindly take my affidavit in opposition.
On behalf of respondent number 1 and 2.
Yes, 1 and 2.
Huh?
Yes, NTPC Limited. Affidavit in opposition on behalf of the respondent 1 and 2. Upon by Vinaya Prakash Shaw.
Yes.
By Vinaya Prakash Shaw.
Yes.
On 8th of February 2020. Yes. Page 9 shows 8th of February 2020.
Yes, got it.
Kindly take paragraph 4 first. The petitioners have not demonstrated 4A, 4 small a. Paragraph 4.
Yes.
The petitioners have not demonstrated any legally enforceable right for maintaining the petition. Petitioners are all non-approved teachers of the primary school, where they claim to have imparted teaching to the students. Therefore, they do not have any semblance of a legal right to claim arrears of pay revision arising out of ROPA 1998 and 2009. The petitioners base their rights on the strength of an order passing another writ petition and entirely contended that they are similarly situated like the petitioners in the said writ petition, big number spans of 2014. However, that is a gross misrepresentation of fact. The writ petitioners in the 2014 petition were teachers whose services had been approved by the Office of the District Inspector School, Murshidabad, whereas the writ petitioners in this case have not demonstrated or produced any evidence in support of their approval by the government of West Bengal. The petitioner being unequal to the writ petition number 2014, therefore cannot claim an equal treatment. If such a relief is granted, that itself will amount to violation of 14. Then my lord, then B. I say that NTPC High School, although carried on classes from classes 1 to 12, only the secondary and higher secondary sections from classes 6 to 12 was recognized by the West Bengal Board of Secondary Education and the West Bengal Council of Higher Secondary Education. The primary section was not recognized. Therefore, there is no question of any approved teaching and non-teaching staff being employed in the primary section of the school at any material point of time. The school has been closed with effect from 30th September 2021 by recording certain facts and observations made in various orders passed by the Honorable Division Bench of the High Court. Then copies of the recognition orders of classes 6 to 12 as annex, marked 1. Kindly take note, the annex are R1. The provisional registration being granted by the board of the Board of Council of Higher Secondary Education, West Bengal Council of Higher Secondary Education.
Yes.
I am directed by the President Council to state that your institution has been accorded provisional recognition for introduction of HS general stream courses with effect from 1991 session for 2 years on the following conditions. This is not therefore from 11 and 12 for classes 11 and 12. Then C. The regulations are admittedly superannuated employees of the school. In any event, their claim is barred by gross and unexplained delay, if not hit by the principle of waiver, estoppel, and acquiescence, and seeking offense. It is, however, primarily submitted that the petitioners do not have any right to claim any arrears of division of pay arising out of ROPA. The school was a private, unaided school, and this petition is not maintainable for money claim of the petitioners, exclusive money claim. I say that NTPC High School was a privately managed school which did not receive any aid in any form from the government of West Bengal. The petition is not maintainable against the private school by the petitioner, since there is no public law element or public interest or public duty or in the purported cause of action. The instant petition is purely to the private and contractual domain, having no public law element in it. It is in the nature of money claim against the private body. Had such claim been lodged in an appropriate civil court, the same would have been barred by law of limitation or otherwise.
Yes.
And paragraph 7. Then we have paragraph 7.
So petitioners were teachers of primary section.
Not recognized.
Not recognized. Primary section not recognized.
Or the higher secondary council.
And their approach is belated approach 1.
They are fence sitters waiting for the decision in the other pending matter.
Yes.
Primary section is totally unrecognized. And it does not receive any aid in any form from the state government. Private, unaided is. Now, paragraph 7. There's side note judgments on the aspects, on the points I am raising. Paragraph 7.
Hmm.
Reference to paragraph 17 to 20 of the said petition,
The petitioner also knew.
I reiterated the contents as the petitioners also knew that they were not entitled to the benefits of successive ROPA and they have no legally enforceable right to claim the same. As such, the petitioners did not claim for the same during their entire length of service. It is stated in this context that it is not even the case of the petitioners that they possess the qualifications for being appointed as approved teachers of secondary school recognized by West Bengal Board of Secondary Education or the Higher Secondary Council. They are contractually appointed by the school on negotiated terms and conditions without creating any right in their favor to get benefits of ROPA. The petitioners have also not been able to demonstrate any legally enforceable right in their favor to get the benefits of ROPA 98 and 2009. The petitioners have, if the lordships kindly see the appointment letters, their appointment letters, page 35 of the
Annexure P4 to the writ petition.
Starts from page 31. Appointment letter
Kindly
starts
come to
from
page
page
21, particular. I omitted to mention page 26.
26.
26 of the writ petition.
Oh.
It is the provisional recognition granted to 6 to 10, not 1 to 5, not primary section.
Yes, 6 to 10.
6 to 10, not 1 to 5. Therefore, that is an unrecognized section.
Initially 6 to 10, thereafter the I say up to 12. Yes.
Not 1 to 5 at all. Then we are paragraph page 35.
Page
35.
Appointment should be 31.
Yes.
Page 31. Kindly take page 31. Appointment letter.
Yes, 31.
Offer, subject is offer of appointment for the post of primary teacher. With reference to the application dated nil and the subsequent interview held on 2488. We are pleased to offer you the post of primary teacher at the basic pay of 300 per month in the scale of 300 to 685, plus dearness allowance under the rules of the school management. Under the rules of the school management. Kindly note this.
Yes.
Then 2. In addition to the basic pay and DA, you shall also be entitled to the benefits of contributory provident fund as and when implemented and free medical treatment to the extent of availability of hospital NTPC Farakka. Then next page, 10. Why I am showing this is, unlike government service or other schools, these teachers here, they get medical benefits of even admission to hospital, NTPC hospital, etc., as well as residential accommodation.
Accommodation, yes.
Number 10, at page 32. They get this. Unlike all other schools. And in the first page, at page 31, I have shown under the rules of the school management, your pay. I come back to my affidavit now.
Yes. Yes.
Paragraph paragraph 10 of my affidavit in opposition.
Yes.
I omit the first 7 lines. Then the petitioners are neither trained teachers. Paragraph 10, 7th line from top.
Petitioner is neither trained.
Are neither trained teachers nor do they have the qualifications for being approved by the government of West Bengal. Such a case has also not been run by the petitioners in the instant petition. Has not been made out. The petitioners therefore sat tight on their alleged or purported right, knowing fully well that they are not entitled to it. Only upon the decision pronounced by this only in WP number 7 that the petitioners have ventured to file the petition at a grossly belated stage. The learned single judge in the Sejnarayan of 2014, he held in favor of the teachers. From that, the judgment, the order of which I have shown to you, Lord, was passed. And only after that, they have filed this. The clear case of density. I shall show judgments on this. That if you wait for the outcome of a particular pending proceeding, and after looking at that order, that some benefit has been given, you approach the court, your petition is liable to be dismissed straightly. That's the principle of offensive. I shall not cite judgments.
Yes.
Then I read on. No effort has also been made to explain the delay for instituting a writ petition after an abnormally long period of time. Your Lordship is aware that your Lordship always insists on the delay being explained. If there is an explainable delay, your Lordships often condone that. But here, there is not a single sentence which says that why this delay had occurred, why they chose to wait for so long. It is not. It's an case of unexplained delay.
Yes.
In paragraph 13, paragraph 43, etc. On the ground, I submit that the same are misconceived and not legally sustainable. Leave is straight for to make appropriate submission with regard to this. The fundamental claim of the petitioner is on the basis that the respondent school was a government-aided school. Such an averment is far from being true. The school did not receive government aid at any time, in any form. The petitioner was not approved by the government of West Bengal. Since he was not teaching in classes of the recognized section of the school, he was also not imparting education within the strength of the teachers sanctioned by the government of West Bengal. Therefore, the question of existence of a legal right to get pay and allowance under ROPA does not arise. It is clear that the petition below ROPA applies to government schools, applies to government servants, but not to private schools. It is clear that the petitioner had been sitting over his alleged right, and he did not have semblance of a legal right till he decided to jump off the fence on a writ petition filed by different circumstanced teachers of the school having been allowed. The decision in the case of Sejnarayan has still not attained finality by reason of dependence of the appeal before the division bench. Now it is disposed of. Then paragraph 14, last sentence, neither in law nor in equity they are entitled to any relief. Paragraph 14, last sentence. Neither in law nor in equity. Your lordship will find another affidavit in opposition, a supplementary affidavit in opposition, which is affirmed by Devolina Das. They had filed a supplementary affidavit, we used another opposition to them.
Oh.
It is not this, affirmed by Devolina Das. It is a judgment of a learned single judge of this honorable court, a coordinate bench, which had specifically held that NTPC is not the employer in respect of the teaching and non-teaching staff of this school. That
দেখুন তো এইটা একটা এটা একটা এফিডেভিট অপোজিশন
Your lordship kindly got it.
এটা ছাড়া অন্য কোনো এফিডেভিট অপোজিশন
This is quite a thick one, like this.
ও এটা তো সাপ্লিমেন্টারি এফিডেভিট একটা ধরুন এটা একটা সাপ্লিমেন্টারি supplementary affidavit. How many supplementary affidavit you have filed, Mr. Sir?
He has filed two.
Huh? Three.
There are our opposition here.
দেখুন তো নেই বোধহয় একটা এফিডেভিট অপোজিশন ছাড়া আর কোনো এটা তো রিট পিটিশন এটা হচ্ছে এফিডেভিট সার্ভিস এইটা একটা এই যে হ্যাঁ দেবলীনা দাস গট ইট
Yes. Devolina Das.
Yes.
Why I am asking the lordship to look at it is a judgment of a coordinate bench, which has held, my lord, that NTPC is not the employer in relation to these persons, these teaching and non-teaching staff. Kindly take page 9. That's where the judgment starts. Page 9.
Yes.
I will not trouble your lordship with all the facts stated here. Kindly straightway come to page 38.
Yes.
After considering the facts and circumstances and the submissions made for me, I am of the opinion that the NTPC, for providing the facilities to its employees, constituted the said school, and thereafter it appears that the organizing committee was created and the said school under the control of the said committee. It appears from the record that the records were addressed by the authorities, that is West Bengal Council of Higher Secondary Education, to the secretary of the said school. It further appears that a body, there is a better copy.
Page 40, yes.
Further appears that a body constituted for the management of the said school. It further appears from the record that the application has been filed for special constitution by the said school. All these facts appear to me that the school was functioning under a committee which has been constituted to run the school only. Because NTPC, my lord, does thermal power jobs. School is not, my lord, their line of business. Only for the benefit of the words of its employees, the school was open. Incidentally, some of the officers of the said NTPC was appointed as the members of the said school, but that does not give an impression to me that the NTPC has the control over the school. NTPC rather, not further, it should be rather. NTPC, rather, on occasions, have given aid to the school to run the same. That does not create any relationship between the petitioner and the NTPC as the employer and employee. Teachers were appointed by the school authorities. Then 42, page 42. page 40, last line, 40 last sentence. It is certain that the school is functioning separately through the organizing committee and not by, then kindly turn to 42, and not
NTPC.
by NTPC.
Yes.
The policy of transfer of the said school is a decision of the organizing committee and is not by NTPC. Therefore, in my opinion, in these facts, I am unable to accept the contention of Mr. Mukherjee appearing on behalf of the petitioners. Rather, the contention which has been forwarded by NTPC is more logical, and in my opinion, I do not have any hesitation to accept the same. And furthermore, the petition is defective in the right of success. Lord, they took out an appeal from this order, but then did not pursue it. 57.
Oh.
They were the alternative.
Yes.
It was in this context, the context of this judgment, that the point of constructive res judicata was taken by Mr. Bhatt. Because if there was a previous litigation wherein there was a claim by the employees towards NTPC as its employer, that's the basis of the case. Now, there they could have raised the point regarding this pay, application of ROPA, etc. 2014 litigation was filed when 1998 ROPA, 2009 ROPA were in existence. They did not raise this claim. Order to civil procedure court. And then section 11 CPC, res judicata aspect. On this, Mr. Bhattacharya had made submissions before the Lord, that the present petition is not maintainable because of that reason. Second aspect that I have mentioned before the Lordship is regarding the delay, inordinate delay, unexplained delay. And Lord, they had been waiting for outcome of another pending proceeding. They retired long back. One of them was in as early as in 2014. He sat for 7 years, others sat for 4 or 5 years. And seeing the outcome of that judgment, they ventured to file this litigation. Now, this is an ideal case of fence sitting. I haven't brought all the judgments on this. Fence sitting judgments were I shall cite before the Lordship on the next occasion, on the next date. And then the other line of judgment that I shall cite before the Lordship is a pure claim for money, not based on where it is not a consequential. A pure claim for money is not meant. That's not another point I shall argue. I shall face judgments on that. One is fence sitting. One is constructive res judicata. Second point is fence sitting. Third point.
Yes.
Then the petition is not maintainable where it does not fall within the domain of public element.
Domain of
public element.
Oh, no public law element is
public law.
Yes. They are employed purely in a private school.
I'm not an employer.
No, they employ. They are employed.
Next, the judgment of justice goes on. I have shown to your Lordship that NTPC is not the employer.
Employer, yes.
No claim is maintainable against me. Even if, assuming that they have a case, it's not maintainable against me. Then the question of limitation. As I said, a limitation in respect of a money claim. Sorry, not limitation. A petition for the enforcement of money claim, simply cited, and not as a consequential relief, is not made. Money claim simply cited and not as consequential. Chapter 13.
Yes.
And another point I'll submit judgments on this. That even if money claim is proved or is accepted by the Honorable Court, then the limitation is 3 years from the date of filing of the proceeding. I don't add additional 2 years. That was a special concession given me. Limitation is 3 years. Nothing beyond that. I'll cite judgments on these aspects on the next.
Yes.
And give me any date where convenient.
Okay. So, yeah, are the learned advocate appearing for the respective parties, list the matter for advance. Okay,
অনলাইনে ছিল তো তো তাহলে আমাকে দিয়ে দাও সাইটেশন গুলো দিয়ে দাও কপি লাগবে সাইটেশন দাদা যে
ইয়েস এবার দেখে তখন আর কি বাকিগুলো ডাকবেন নাকি আগে কি 3:30 আছে 3:30 তো নেই এখন আর কি আর দুপক্ষ if both sides are present in any matter, what can be done?